I consult with so many people who want to sponsor their parents for a green card. They are US citizens and their parents entered without inspection, and they don't know that their parents might be eligible for adjustment of status through an old labor certification. So you would not believe how many people, come to me on a whim and say, I know we probably can't do anything. My parents entered without a visa. I'm now 21, but we want to make sure, that in fact, there's nothing that we can do. And then when I get to talking to the parents, they've been here since the 80s or 90s. And I said, well, did your employer ever file anything for you prior to the 2001 sunset date? There was a big rush in 2001 because they announced this sunset clause where people essentially who had petitions filed for them would not leave the United States. It would protect them in the future with future benefits. And now it's 245I protection. That's what it was. And they said, well, my employer started the process, but they never finished. And I'm talking to these dads who are 60, 70 years old, and they say, yeah, but nothing ever happened. They didn't even file the petition. Maybe they just filed the labor certification. And I go, that works. If they filed the labor certification, that is enough, and that will protect you under 245I. Additionally, their spouses are protected, even if the individual originally sponsored has passed away. So, for example, if an employer petitioned for your dad in the 90s, nothing happened, your mom, they were married, your dad later passed away, but now you want to petition for your mom, she entered without inspection, your mom can still benefit from that. Children can also benefit if that family relationship existed at the time. So for those of you who have consulted with attorneys your parents have been here, or your family members have been here for so long, since the 90s, there was a big rush in 2001 to meet the sunset clause, and employers were filing labor certifications for people left and right. And even if nothing came of that, that can often still be used for 245I protection to adjust status in the United States despite not having a lawful entry. So it is worth a conversation.